Hi, good morning, everyone. Welcome to the webinar. This is What to Do When a Loved One Dies, and I'm J. Marie Schaefer. I'm going to be presenting today, and I am a partner at the Herzog law firm, and one of the many things that I do here is to handle estate administrations. So we're going to talk today about what you need to do kind of from beginning to end to handle the process after a loved one dies. So before I begin, if I could just ask everyone to hold their questions to the end. There will be time for questions at the end. If you want to ask a question, you can use the chat box at the top of the screen and I will answer your questions at the end of the presentation. Or at the end, I'll allow everyone to unmute themselves and you can just ask questions and we can talk then. All right, thank you. All right, so let's start. Okay, so what happens immediately after someone passes away? And frequently we get calls, right away when that happens to someone who was one of our clients. And because the family members are uncertain about what to do, they're kind of in shock or they're in grief, and they know they need to know what to do and what to do first. And without any plan, this is a time where we see lots of tensions come up between family members, between the children or other family members. And, while you can't always, get rid of all of that, if you do have a plan ahead of time, if you had a will or if you made your intentions known, that can really go a long way towards easing some of those tensions. Another frequent thing that people fight over is personal property. So one suggestion we have when we're doing a will with you is to go through your assets and make a list of your personal property and who you want it to go to, which family member. And again, that is, some of this advanced planning can help your family after you're gone to make things a little bit easier for them. So the first thing people want to know is who is in charge, right? And if the person was older and they had, they needed some help for someone to take care of them, there probably was a power of attorney in charge. And the power of attorney, that person is in charge of taking care of things while you're alive, but when you're incapacitated. So your power of attorney may have been paying your bills for you or handling your legal things, but the power of attorney dies when you die. So it's not effective after your death. So that power of attorney, the person who was using that can no longer do things with the power of attorney. Also, if instead of a power of attorney, you had a guardian who was appointed by the court, generally those powers end and the guardian has very limited powers, basically to take the assets and then turn them over to whoever the executor is. Now that may be the same person, and the guardian may also be the executor, but legally they have to get appointed as the executor first, which we're going to talk about that process and how you get appointed as the executor. So, there may not be anyone legally in charge yet. There's going to be a little bit of a gray period there where there is no one while you're waiting to have an executor appointed by the court. So there may be some things that you can do. Frequently, parents put their children on their bank accounts with them so that they could continue to pay bills after their death. So that's really a good idea to do if you, are helping your parents or another older family member with paying bills. You should consider having yourself put on their joint so that there is no gap in paying for bills after they're gone. They could also, instead of making you joint on the account, they could name you as a beneficiary on the bank account. So banks do let you name a beneficiary. It could either be called an ITF, which is an in trust for account, or a POD, which is payable on death. Either of those designations would work. And then that allows you to go in and take over that bank account and continue paying bills. So those are two ways you can make sure there's, money in the short run while you're waiting for the executor to be appointed. In terms of immediately, paying for things, you do have a funeral to pay for. So another thing you could do is do a prepaid funeral arrangements, and that's where you go to a funeral home in advance and you pick out everything that you would want, and then you pay for it in advance. So that does help your family members, because when the time comes for them to make the arrangements, it's already been paid for and you've already picked out everything that you wanted, so they don't have to guess about what you would want. So those are a few things that you can do to help that gap between when, the power of attorney ends and before an executor is able to take over. So if you have a will, the executor is going to be the person who's in charge. If you don't have a will, that's going to be an administration process, which we'll talk about again in a little more detail. And in an administration process, right, because you didn't have a will, you didn't pick someone to be the executor. So generally one or more of the family members can step up and become the estate administrator. So that would be something that among the family, you would decide who wants to do that, and then that person is the one who would be in charge going forward. So who do you notify immediately after someone's death? And this is kind of just a general list. So of course, after you're notifying family and friends and and the employer, if the person was still working, you're going to call your attorney if you had a will, right? Like I said, we often are one of the first people to get a call, and then we can help point you in the right direction and help you get organized. The funeral home, when you go to the funeral home to make the arrangements, generally they notify the Social Security for you. So if you were receiving Social Security payments, the funeral home is going to notify them, so they will stop those payments. Now, frequently they will, because you're paid in advance. So if you did receive a check for the month that you passed away, the Social Security is going to take that check back. And since most Social Security checks are direct deposited, they're going to directly withdraw the amount, right? So they're going to take that money back out. So again, that's something to be aware of when you're looking at the checking account, to realize that, not all that money may stay there because that Social Security check may be withdrawn. Some other places that you will need to notify is the tax, IRS in New York State. When you file income tax returns, you will notify them. Your pension and retirement. So that's pretty common. If you have pension and retirement plans, you're going to have to call and notify each of those places. And again, like the Social Security, sometimes they may take back that month, or sometimes they may prorate it. So that is just something to bear in mind when you're doing that. And then also certain kinds of retirement plans, if you have a state retirement plan, for example, there's often a death benefit. So that if you don't know about that, that's something to ask when you call the pension company to see if there is a death benefit available to the survivors. You're going to want to notify the banks because you do want to let them know so that no more activity can be done on the account. And unfortunately, there is not often, but there can be fraud, after someone passes away. If someone knows that they may have access to banks or information or credit card information, they could go out and try and charge things. So you want to notify not only the banks, but the credit card companies as of the person's date of death, so that the accounts can be frozen and you can be protected going forward. Utility companies, you're going to notify them, but if there is a house that you're going to sell, you're not going to want to turn those off, right? So you're going to want to keep those on until you can sell the house. DMV, there is a form that you can use. So if you have a car that you want to transfer to a family member, you are able to do that at the Department of Motor Vehicles to transfer it to a spouse or to the children. And you're allowed to do that for one car. And sometimes you can do that before you go to probate or while you're waiting for probate if you need to get that car title immediately transferred. So those are some of the immediate things that you can do. So I just I'll try and address some of the questions while I'm going along. I may not be able to always, but one question is, how soon after death is the death certificate available? And generally, the funeral home arranges for that, and it's usually a couple of days. The only time it takes longer is, if there's suspicious circumstances, but normally I would say it's available within a couple of days to a week, and the funeral home gets them for you. And then, yes, the other question was, will there be slides available after the presentation? I should mention that we will be emailing everyone who's attending a copy of the slides, so you can go over these at your leisure afterwards. Okay. Oops. Okay, so, what other immediate actions do you need to do other than notifying all those appropriate places? When you have a house, you really have to go through the house, or the doors and the windows locked. It's winter time, so pipes can freeze. So you want to make sure that the heat is on, or that you've taken care of, turning off the water to the house. You want to secure the house. You want to make sure you try and pick up the mail or cancel any newspaper subscriptions. You don't want it to look like the house is empty, right? We did mention placing a hold on the bank and the credit cards. And then you also want to go in and kind of take a rough inventory of the cash and the valuables. And that's going to help you, if you're the executor later on, to show your other family members what was in the house. Now, you don't have to do that every time. If you're a family that gets along, that's probably not necessary. But if you have any hint that you think someone may argue about something, it's best to take an inventory, and then before everyone gets there, so you can show what's there, and then that will help you when you're dividing up those assets later on. If you're going to do an estate sale, for example, sometimes those places will come in and do an inventory for you, so that's something else to think about. So in terms of the next thing you have to arrange is the funeral service, right? And if you have that pre-planned arrangement, that's very helpful. Another document to look for is something called a disposition of remains appointment. And that's a form that you can sign where you designate two things. So first, you designate a person to make your funeral arrangements for you. And then secondly, in that form, you can say specifically what you would want, so if there's a particular cemetery or a particular church where you would want the service done, you could write that down in this form, and hopefully give it to the people who are involved so they would know exactly what you would want. Now, if the funeral has not been pre-planned, the question is going to come up is, how do you pay for the funeral? And like I said, a lot of times the money from the estate is not going to be available until an executor is appointed. So sometimes family members pay themselves out of pocket, right? And then they know that they can get reimbursed later from the estate. If the family members don't have the money, oftentimes the funeral home will wait until an executor is appointed. It's pretty common, they know that. And they'll be put on notice of the proceeding, because they'll give you paperwork. They'll give your lawyer paperwork to file with the probate, so their debt's known, and they are one of the first people to get paid once money is available. So now that kind of initial, you've kind of notified people, the funeral is over. Now you want to look for basically the will or any other documents. And hopefully they're organized in a place where you can find them, right? But that's not always the case. Sometimes, your parents have told you where they keep all their documents. If not, you're going to go look in the most logical places, right? Is there a filing cabinet in the home? Is there a safe in the home? Did they have a safe deposit box? Did they notify you about that? Now, a safe deposit box is tricky, because if the safe deposit box is just in the decedent's name, no one else can get into the safe deposit box. It's frozen on that person's death. So you have to go to court and ask to be appointed. It's a special proceeding where you're appointed just to open the safe deposit box. And you go in with an officer of the bank, you open the box, they inventory what the contents are, and basically they're just looking for a will. So if there's a will there, then you can remove that and bring that to court. And then everything else has to go back in the box until you're appointed as the executor, and then you can go back and get the other documents out. So because that's kind of burdensome, we really recommend that you don't use the safe deposit box. You know, a lot of lawyers, you know, we, for example, keep the original wills here so that you don't have that problem, so that when someone passes away, we have the original will in our office that we can file with the court. But if you do want to keep it, you know, try and keep it at home in the safe box. If you're absolutely, you know, want to use a safe deposit box, then make it a joint box where someone else is the owner on the box with you, so that person could go in and access it on your death. They wouldn't have to go through that court proceeding. Do the fiduciaries have copies? So a fiduciary, that means the executor or the trustee. It's a good idea to give them copies so they know that they're the ones who are in charge, and so they have some idea of what to do ahead of time. And then the attorney's office, you know, most attorneys, all attorneys' offices will have copies of the documents that you signed. So in addition to looking for the will, what other documents are you going to look for when you're putting together everything? So these are some of the things that you're going to look for. And in fact, when we meet with you, we give, after someone passes away, we do give you a detailed list of documents to bring to that first meeting. And it kind of helps us put everything together. So we're going to look at your estate planning documents. You know, other than your will, maybe you have a trust, right? So we're going to look at the trust. Tax returns, your last year's tax returns. Those are helpful to look at because from the tax returns, sometimes we can, oftentimes we can tell where you have your investments or where you have your retirement accounts. So that helps us you know, find things. If there is no good list of where the assets are, we can kind of determine some of that from your income tax return. You're going to need deeds to any real estate. We want to see how the real estate is titled, so we know what to do with the real estate. You know, real estate can be owned jointly with someone, which means it goes directly to them, or it may not be, and then it's an estate asset if it's owned individually. You're going to want to bring all the bank statements that you can find, so we can see where your accounts are held, and again, how the title is on those accounts, whether they're individual or whether they're joint. Any life insurance policies, you know, original policies are helpful, or more current statements that you have that show what the current value of the policy is. Those are helpful. Sometimes people bring in old policies. They don't even know if they're still in effect, but that's fine. It's always, you can always write a letter to that company and find out if that policy is still valid and get some information. Information on any retirement plans, you know, so a 401k or an IRA plan, whatever that statement is, or wherever you have your pension from, you know, whether it's from your private company or from the state or the government, information about that retirement. And then outstanding bills that need to be paid. I mean, typically we're looking at, you know, medical bills or utilities or credit card bills, real estate taxes. So anything like that to try and start to get a handle on what has to be paid. So after we get all these documents together and we look everything over, now we can start the legal process of probating the will. So that's what needs to happen before any of the assets can be distributed out to the beneficiaries. So there's two ways we can do this, right? If you had a will, then you go through the probate process. And if you don't have a will, you're going to go through the estate administration process. So both ways you're going to court, right? A lot of people have this mistaken impression that if you have a will, you don't need to go to court. which isn't true. You do have to go to court. The difference is in the will, you've written down exactly what you want to happen so that those wishes will be followed. If you don't have a will, then it's going to go under the laws of intestacy. So if you don't have a will, the laws of intestacy state who would inherit the property. And it's going to go basically to your next of kin. There's an order that it goes in, and what you would think it would be, it goes to your spouse and your children. If you don't have a spouse and children, it would go to your parents and then to your siblings. And then it goes further out than that, to aunts and uncles and cousins. So there is a list of who would inherit property if you did not have a will. So the probate process, it's basically the process is to prove the will or to make sure the will is valid. So you need to file a probate petition with the court. You're going to file the will with the court. The court's going to review the will. There's going to be an affidavit of witnesses with the will. So when you signed a will, there were 2 witnesses there to make sure that you had the capacity to sign. Your will names an executor. It may name trustees. So the court reviews all of this information. And then at the end, they're going to appoint the executor. They're going to appoint the executor that you named unless someone objects to that. One thing to keep in mind is that all probated wills are public record. Most people don't really care about that, but it is just something to know that it is public. Anyone could look at it. Whereas if you use a trust, for example, that's going to be private, and that's going to be outside of the probate process. So what types of property do pass in probate? Anything that's in the individual's name alone, that's subject to probate. Things that are not subject to probate are things that are jointly titled. So a joint bank account, real estate that's owned jointly, that goes to the survivor. Any assets that have beneficiary designations. So that's most of your retirement accounts and your life insurance policies. All of them have beneficiaries named on those accounts. And those are going to be distributed right to the beneficiary just by filling out a claim form and presenting the death certificate. Those do not have to go through probate. Once in a while, they may end up in probate. If you didn't name a beneficiary, or maybe a beneficiary died and you did not have a contingent beneficiary, that could end up in probate. You also don't want to make the beneficiary on any of these accounts your estate, because then you do need to go to probate to have someone appointed for the estate to receive the assets. Another category is property held in trust. So we do talk about trust frequently in some of our other webinars. There are 2 types of trust. You can do a revocable trust, and you can also do an irrevocable trust, which is for asset protection. But basically, the idea of a trust is that the assets in the trust avoid probate and they go to your beneficiaries directly. So that's another way to avoid probate. I won't go into more detail in trusts in this webinar, but like I said, we do have other webinars. We have a wills versus trust webinar, which explains that in more detail, and you can check on our website for the schedule, or you can also on our website, we have pre-recorded webinars, so you could go look at one of those. So there are levels of probate, right, based on the size of the estate. So there's a small estate, and that's if the total probate assets are under 50,000. And then the full probate, or the regular probate, is if the assets are over 50,000. Now, the small estate proceeding is, easier, it's shorter, but you still have to go through court, right? So you're still filing everything with the court. It's a little bit more simplified rather than the full probate proceeding. Now, these are filing fees. When you file a petition with a court, there are filing fees based on the size of the estate. So these are just strictly the court filing fees. These do not include attorney's fees and other costs. So you can see if you have a small estate, it's only $1 to file that. a petition with the court. But other estates, it ranges from, 215 at the lower end to 1,250 for larger estates. So starting the probate process, a lot of questions we get from clients are, can I do this alone? And I say, it depends on the size of the estate. You can try and do the small estate proceeding on your own. Some people do. You can get the forms online. I wouldn't say it's for everyone to do, but if you're kind of good with legal forms and the computer, you probably could do that on your own. But I would not suggest doing the full probate by yourself, because there are a lot of pieces to that that you may not know as a layperson, right? So you should use an estate administration attorney when you're doing a full probate. So you're going to file the probate petition, as I mentioned, with the court. And then there's the notice provisions. Okay, so what the notice provisions, this is who you have to give notice of the probate to. So everyone who's in the will, right, has to be notified. And you also have to give notice to all of your distributees. So this is anyone who would inherit the property if you died without a will. So if you're not in the will, it's kind of like, the person decided to not give you money for some reason. So you're getting notified because you would inherit property if they did not have a will. And it's kind of like a chance for those people who are naturally entitled to the funds to see if they want to object to the will, right? Because they have an interest in the estate. And when they receive the notice, they can either, consent or not, or they can object to the will. You're basically given a date by which you have to object to the will. And if you do object, then the next step is that you have a hearing on the validity of the will. And I'm not going to go into a lot of detail about these will contests today, but they can be, very involved. But basically what you're doing is you're interviewing the two witnesses to the will. And like I said, their purpose was to be there when you signed the will to state that you had capacity to sign it. So this process is involving questioning them, looking at medical records, seeing if you have capacity. Another way they could contest it is to see if someone was influencing you, if you were under duress. So the questioning is meant to bring that out. And if there's a question there, you can file objections to the will. Now that's not very common. It's not the majority of our cases, but it does happen from time to time. Another document you have to file is a family tree, and not your full family tree, but just, kind of state who are your immediate relatives, those people who are entitled to notice, who's your spouse, who's your children, who, if you don't have that, who are your parents and your siblings. And you need someone to sign that who's not in the immediate family. So the court knows who the immediate relatives are and who needs to receive notice. Now, sometimes we have, clients that don't have like I said, an immediate family, like their parents are deceased, maybe they don't have siblings. And then we have to look further. And sometimes you don't really know who those further people are. So you have to we have to do the research, or you have to hire a company to do some genealogical research to see who your relatives are. And in those rare cases, it can be quite a process to try and find who would be the people to inherit. If you hire a company to do the research, it can cost thousands of dollars to try and do a full search to find any heirs. See. I just saw some questions in here. All right, I'm just going to kind of do a few questions here. So which court is the probate filed in? So this is important. You are filing your probate in the county in which you resided when you died, right? So wherever the last residence was that you have. But like if you're in state, if your residence is here, but you died in another state, for example, I see that as one of the questions, you're still going to file the probate here. You know, a lot of people do go back and forth, for example, between New York and Florida, but generally one place is going to be their residence, and that's going to be where you file the probate petition. Another question I have is if you have a will, do you still need the family tree? And the answer is yes, because the court still needs to find those people to give notice to, right? And it may be the same people that you have in the will. So, you know, if I have a will, I'm going to leave everything to my husband and my 2 children, right? And they're the people who would be entitled to receive notice. So my family tree affidavit would just say that I was married and I have 2 children. So that's kind of straightforward, but it can get more complicated, like I said, in different situations. So going on, so dying with a valid will. So this is kind of what you're looking for when you're trying to prove that the will is valid. You know, the capacity of the witnesses. This is an important one. The witnesses can't be anyone that you have named as a beneficiary in the will, right? Doesn't that sound kind of, you know, self-serving, right? If I'm the beneficiary, I can also witness the will. But sometimes when people do the wills themselves online, they print out a form online and they may not know that. So they may have people named in the will be the witnesses, and that's going to make the will invalid. Also, and this happens, I see this a lot, that someone will make handwritten changes on the will. You know, maybe they're leaving percentages to grandchildren or nieces and nephews, and then they change their mind and they may write in a different percentage. Well, that's not valid, even if it's initialed by that person. You would have to sign a codicil, which is an amendment to the will, or you'd have to sign a new will that incorporates those changes. So those are kind of some things that people do make mistakes and invalidate the will, you know, not on purpose, just by accident. Oops. Okay. Before I get into the probate process, let me see. I was just trying to catch up on some questions. So domicile. Okay, so domicile means, so domicile is what your residence is, right? And so when you sign your will, you're going to say, all right, I'm domiciled in Albany County, right? Even if I move later on to a different county, let's say I moved to, I don't know, Columbia County, right? And I die in Columbia County, that's where my will is going to be. It's wherever I'm living at the time, even though the will may say something different. Let's see. So if your address changes, yeah, the will is still valid. It doesn't matter where you're, if you move, as long as it was valid when you signed it. And then I'm kind of starting to talk about the probate process now. And one of the questions is, how long does it take? So the whole probate process, it's at least 7 months long. So from the time that you're appointed as the executor, the estate has to stay open for at least 7 months. And that's to give creditors an opportunity to file any claims. That's the minimum period that they have to file a claim. Now, during that 7-month period, you can go ahead and pay bills. You can even make some distributions to the beneficiaries, but you can't finalize the estate until at least 7 months. So some estates are wrapped up in that 7-month period. Maybe it's more typical to go out to about a year, because you do have to think about filing tax returns. So that's kind of the range of a normal probate would be in between that 7 months to 1 year period. So during this time, after you're appointed as the executor, there's these tasks that you have to do. So one of the first things you have to do is identify and create an inventory of all the property. And like, we're not looking for a really detailed inventory of the household assets, you know, like, you know, dishes and china and pillows, but, you know, the financial assets. And you have to file an inventory with the court of all the financial assets that you have found that belong to the estate. Your next step is to collect those assets. You know, if it's money or liquid assets, you're going to close out the accounts and put them all into an estate account. And the idea is to get everything into one estate account. from there, from that estate account, you are going to pay any expenses of the estate. You're going to pay off any debts. You're going to pay off any taxes. And you're going to keep an accounting of everything that you paid. Now, when you're ready to close the estate, you're going to give all the beneficiaries an accounting. Now, it can just be an informal accounting. That's most of the time when everyone's on friendly terms. You just show them what money you gathered, what bills you paid, and then you show them how much is left to split up. And then before you make those distributions, after everyone agrees on that accounting, they have to sign a receipt and release agreement. So if the estate ended up with $1,000 and it's, two beneficiaries, they each sign a receipt agreement saying, all right, I agree that I received $500 as my share of the estate. And then you file a final report and that gets filed with the court. You do, if you have real estate, of course, that's a little bit complicated. Well, I mean, not terribly complicated. You're either going to give that real estate out to a beneficiary, maybe the house was left to one person, or if it's not left to any specific individual, more commonly the real estate is sold. So once the house is sold, that money goes into the estate account and then it's split up under the terms of the will. You do have to file tax returns. You have to file an income tax return, a final income tax return. You may have to file an estate income tax return. It's not common, but the estate is going to be open from the time that the person passed away until the time that you distribute the assets to the beneficiaries. And if you have stocks or bonds or something that is earning dividends and income, the estate would have to pay income taxes on that before it gets distributed to the beneficiaries. So that's a time when you may have to file an estate income tax return. Now, the other type of estate return is the estate tax. And these days, most estates do not have estate tax due. The limit in New York State is about $5.6 million. So if your estate is under that, you don't have to pay any estate taxes. And at the federal level, it's over $11 million. So again, most people don't have to pay that. So your beneficiaries, when they receive their share of the estate, they're not paying any estate taxes on it. Generally, the only tax they may have to pay is income tax when they receive an IRA or a 401k. They get to roll over that IRA to themselves and spread out the income tax. They can spread it out over 10 years, or they could take it all at once and pay income tax on that. And that's because of the special nature of the IRA, is because the tax was deferred on that, and you only pay tax when you take it out. So again, that's the only type of tax you would pay generally, is income tax and not estate tax. Okay, I'm going to see if there's some more questions here. Okay. So question is, if you're a beneficiary, how can you check on the probate process? So that you have to check in with the executor, right? You're relying on the executor to do that. I mean, you can see what's filed with the court, but the only thing that's really filed with the court is that inventory. And then, so generally, if we're representing a beneficiary, we tell you to ask the executor what's going on or what the status is, and hopefully you get that information. If it's a situation where this has been going on for a very long time, or you're not receiving information from the executor, there is a remedy for that, and you can file a request for an accounting. So if the executor isn't giving you an accounting voluntarily, you can require them or ask for them to give you an accounting. And they do have to respond to that and show you what's been going on in the estate. So in some cases, you do have to do a formal proceeding like that. In terms of the tax returns, generally you don't get to see the tax returns, but if you are requesting an accounting, you can ask for a copy of the tax returns in that request for the accounting. There's another question about the bank accounts. So does the bank account freeze if there's a second person on the account? And that's no, right? So if the account's joint, it's just gonna go to the survivor. It won't be frozen. You can still use the account. But if there is no other person on the account and there's an executor appointed, yeah, the account will be frozen until the executor is officially appointed by the court. And then the executor can go take funds out of that bank account. So you do have to wait for the executor to be appointed. Okay, so I think, well, we addressed this a little bit, but how long does it take? And I was saying 7 to 9 months is really kind of the minimum time for simple estates. Larger estates can be, 12 to 24 months. Generally, the only thing that keeps them open longer is waiting to sell real estate. That can keep the estates open longer. Not as common, but if you do own a business, that is going to make the estate process longer because you have to sell the business or transfer the business to someone. And then in the event there's litigation, it can go on for a very long time. People fighting over, in the initial stages, they may fight over the validity of the will. In later stages, they may fight over the accounting about how things were handled by the executor. So both of those can take a long time and it's very costly. So what bills do you have to pay as the executor? So, a creditor can file a claim against the estate, but you're also going to be receiving bills because you're going to have the mail forwarded to you. So you're going to pay all the bills that you know about, but you're only paying the bills from the probate assets. So sometimes the estate is very small, maybe because the house was in a trust or the house or the bank accounts were joint with the surviving spouse. So the actual estate, the actual probate assets may be very little. And sometimes the bills are more than the estate. So in that case, it's important to remember that the executor is not personally liable for the debts of the estate. The executor only has to pay those debts from the estate assets. And if there isn't enough to pay everyone, then it goes unpaid. If there's several creditors, you would, and there's a little bit of money, you would just pay them each a pro rata portion. But you don't have to go into your own pocket to pay the bills. If you were, a spouse or a child of the decedent, again, you're not responsible for the decedent's debts unless you co-sign something, right? So if you're jointly liable on a debt, like so on a mortgage, right, where both you and your spouse sign, you still have to pay the mortgage. But any other debts that were just in their own name, you don't have to pay as the surviving spouse. And in fact, we often have to write letters to credit card companies or to creditors, to say there's not enough money in the estate, and you can't be paid out of the estate. You will get high pressure phone calls from credit card companies, but it's best just to ignore those or just to write a letter saying that there isn't enough money in the estate to pay all the bills. So next question is whether a creditor can go after non-probate assets. And no, they can't go after family members, they can't go after relatives. They can't go after trust assets, right? Those are protected. They cannot go after what you have placed in your trust. They can't go after other non-probate assets, for example, life insurance or a retirement plan, because those have beneficiaries. That goes directly to the beneficiary and that goes outside of probate. So again, those assets are protected from creditors, right? So it's only very limited assets, right? Only the probate assets that are subject to collection by creditors. I did see a bunch of questions pop up around this. Let's see. So the bank accounts. Okay, so a question is, if the bank accounts are in the name of a trust, when can the trustee assume control? And it's basically immediately upon the death. So immediately upon the death, the successor trustee takes over and is able to handle the trust assets. So that is really one of the benefits of the trust, is that you can immediately manage the assets and pay bills and avoid going to court and avoid going to the probate through the probate process when you do have a trust. Okay. Oops. Okay, so what are the costs for probate or administration? So there's a wide variety of costs that may come up. So there's the court fees that we already talked about, the filing fee for the court. Some of these are common, some of these are not common. So the heir search fees, that's not that common, that we have to search for lost heirs. Executor's commissions. So the executor is entitled to a commission. The commission is on all of the probate assets. It's basically 5% of the probate estate. The executors can decide whether to take it or to not take it. If they do take the commission, it is subject to income tax. So that is one thing to keep in mind. Generally, if you're the spouse or the child and you're going to receive the money anyway, you're not going to take the commission. But if you're, maybe a more distant relative and you're responsible for the estate and you're splitting it up among many different people, there's work involved and you should pay yourself for doing that. So if you had to clean out a house, for example, and sell the house and then divide it among, many different nieces and nephews, that is work and you are entitled to a commission for that. There are the legal fees, right, for having a lawyer handle the probate and administration process. And we handle that on an hourly basis. We feel that's the most fair to the clients because each estate is different and the amount of time that's spent on each estate is different. Some lawyers charge a percentage of the estate. We don't do that. We don't necessarily feel that represents fairly the amount of time that is spent on each file. Other fees are, appraisal fees. You may have to have real estate appraised to decide how much it's worth if you're going to distribute that to a beneficiary. There are accountant fees for filing income tax returns. And then some of these others, again, are less common. A bond. Sometimes a court will require the executor to file a bond. And again, that's more likely in a case where it's not a close family member or it's not a family member at all who's serving as the executor. The court requires them to file a bond, which is kind of like an insurance policy that they will not run away with the assets of the estate. So you have to pay a bond premium. Service of process, that's if you have to find and locate people and serve notice on them. Again, that's not a common expense. A guardian ad litem. So this does come up. It's not as common. So if you have a beneficiary who is incapacitated, right? So maybe the surviving spouse is incapacitated. Maybe they're in a nursing home or they have Alzheimer's. Maybe you have a child with a disability who's incapacitated. Anytime there's an incapacitated person, the court is going to appoint someone called a guardian ad litem. And that's an attorney appointed by the court just to represent that person's interests, to make sure that their interests are protected, because they can't speak up for themselves because they're incapacitated. And the guardian ad litem does get paid. So that is an added cost that can come up in some cases. And then the bigger expense is litigation expenses. Again, not very common, but it does happen. So what are some of the potential complications you can face in an estate? So these are some of the situations that we encounter, assets that may be complicated, like a business asset. Minors, we didn't talk about this. So if you have a minor who's a beneficiary of a will or of an estate, the legal age of majority in New York State is 18. So once that person reaches age 18, they can receive their assets. Unless in your will, you've designated a different age. So frequently in the wills that we do, we designate a later age because we don't feel that someone at 18 has the financial, responsibility to inherit a large amount of money. So in our wills, we can say that it's going to stay in trust for a child until they reach a certain age. So either in that case, or if they're under 18, you have to make arrangements to hold that money until they reach a certain age. We mentioned incapacitated distributees. That's the ones that need a guardian ad litem. Predeceased beneficiaries, you have to look to the will to see what that says. If someone predeceases, does it go to their children? That's kind of typically what it says. Or it could say it just, it doesn't go to their children, it just lapses is the word, legal word, and then it just goes to the other beneficiaries in the will. If you have a charity as a beneficiary under your will, that's another little added expense, or some more time that has to be spent because you have to notify the Attorney General. The Attorney General represents all charities in New York State, and you have to send them the accounting and show how much is going to the charity, and they have to sign off on it. Some of the others that we've already talked about, out-of-state property, I'll just mention that one. So if you have real estate in another state other than New York, you have to do, it's called an ancillary administration. So you have to do a court proceeding in the state where that real estate is. So you may have probate proceedings in 2 different states. So if you live in New York and you have a house in Florida, you're going to start with your probate in New York, and then you're also going to have to do a proceeding in Florida to handle the Florida property. So that can be costly. One way to avoid that is to have a trust for both pieces of property, so you don't have to go through a court proceeding in both states. So we've been talking a lot about probate. So why do you want to avoid probate? And there are a lot of reasons why people try to avoid probate. Some of the reasons that we've talked about. Here's some other reasons. One is the privacy, right? You don't want anyone to know what's going on. Minimizing fees, right? Because probate can be expensive. It can, add up over time what the fees are. Avoiding loss due to delays in probate. So because probate can take several months, there's going to be a period of time where you may not be able to access funds, right? Or to move stocks or to sell real estate. You could suffer some financial loss while you're waiting for the probate process to go through. Another reason to avoid probate is protection from will contests. So oftentimes if someone feels that, if someone is going to cut someone out of the will and they feel that they may object to it, instead they may choose to use a trust. So because the trust doesn't go through the court, it's not automatically open to the contest. The beneficiary, or not the beneficiary, the person who was cut out of the trust could contest it, but they have to go hire a lawyer and file their own court proceeding to object to the trust. That's much harder to do than it is in a will process. Another reason to avoid probate is to minimize the amount of time that it takes. If a probate is going to take maybe a year on the average, a trust could be distributed in a couple of months. There's no reason to wait. You don't have to wait for the required creditor time, or you don't have to wait to be appointed by the court. You can do things very quickly. So these are ways to avoid probate. If you want to avoid probate, the joint assets is one, to put assets in joint name with your spouse or with your children. Assets with beneficiaries, you want to make sure that any type of asset or account you have, if you can name a beneficiary, that you do so. Lifetime gifts. If you are going to gift money to maybe your grandchildren, you may want to do that now while you're alive and put it in an account for them, rather than wait for the probate to do that. And then trusts are a way to avoid probate, both the revocable and irrevocable trusts. So that's one of the many reasons that it's good to do a trust. Another reason to do trust is the asset protection piece for nursing home costs. And again, like I said, we talk about those in some other webinars, not today, but for today, it's important to know that trusts avoid probate. All right, so I am at the end here, so I will open this up for questions. So I'm going to look on the chat box and see if there's any questions up there. I also just check the box, so if you want to unmute yourself and ask a question, you can do that. Also, if you think of questions later on, we do offer free consultations, so you can call us or email us to set up an appointment to talk about your questions individually. And you can find out more information on our website, www.herzoglaw.com, where we do have a list of upcoming webinars and, as I said, pre-recorded webinars. If you want to watch this one again or watch another one, you can go ahead and watch them at your convenience. Let's see. So there's a question. Can the executor receive more than 5%? Generally not, because that's the statutory rate that's set by the New York statutes for commissioners. If it was in a very complicated case, maybe you can make an argument that you would get more, but generally that doesn't happen. And in terms of the lawyer's fees, like I said, that's going to vary. It's going to depend on the number of hours that the case takes. If it's a simple case, right, it's not going to be as expensive. I will say that when we bill clients, we also have paralegals do a lot of the work on the file, which does tend to keep costs down as their hourly rate is lower. But it's hard to give an estimate. It really depends on each case, you know, what the assets are, what the family situation is. When we do meet with you and then we get all of that information, then we can give you a better idea of how much we estimate it to be based on looking everything over. Does anyone else have any questions? Did I miss any questions? All right, I'm going to assume there's no more questions. Thank you for listening today. Hope you found this helpful and informative. And like I said, if you have any questions after today, feel free to call or email us and we can answer your questions for you. Thank you and have a wonderful rest of the day.